And joining me now is lawyer Kamodo Ganjo and Steve Ogola, and you're both welcome to the program. Let's start just with an outlook of what we are witnessing in this particular petition, and how is it different in any way from what we saw in 2013? Kamodo.
I think the first place to start is somewhere where we never do as a country, is to congratulate ourselves about how far we have come. In very few years, we have come from the point where people never used to be allowed to prosecute presidential petitions because you couldn't serve the president, to the point where today the petition of presidential candidate was in court, and was able to participate in the proceedings, and the court allowed a lot of room it was very accommodating to other parties. I think two main things were different between 2013 and now. One is that I think the lawyers have internalized the challenges that the timelines in the Constitution pose for them, and so therefore they were more prepared in terms of ensuring that they presented most of their significant evidence in time. Number two, that they were a lot more prepared in terms of their authorities and the law, and they were even a lot more organized in terms of their presentations. They were succinct and to the point. So that was very, very important for the flow of their arguments at both levels. And for the court itself, I think the court learned some lessons from 2013, both in terms of perception and reality. There were many people who felt that the court was more concerned about procedural justice than substantive justice. And I think this court tried as much as possible, within the limits that the technical rules require, to still allow for a lot of the substantive issues to still be looked at, so that it allowed even some affidavits that were alleged to have filed late. It allowed access to limited access, of course, to the IBC servers, and that was important because it could have the court could have argued there's no time, and I think that was what was argued by some of the parties. But it did allow certain limited access, which would allow the parties to prosecute their case, but at the same time not prejudice the timelines that the Constitution gives. So you sense that the court itself is maturing, and I think the parties are also maturing in recognizing that they must make a strong case within strict timelines.
Steve, I want you to go straight into the case that parties were making, and let's start with the petitioner. And there may be three general issues around which they built their case, and let's start with accurate and verifiable results. We heard them talk about fake 34As, massive irregularities on different scales, at least those acting for NASA, and later even when Ekuru Aukot's lawyer joined in, he cited places like Bahati and Kuresoi South where forms 34B were not the same as what was granted on the public portal system. So a lot of issues today surrounding the accuracy of the results and the ability to verify that those are in fact the real results. What do you think was the backbone of such an argument?
Well, I think the substratum of the petitioner's case was that the election was falsified every step of the way, and they tried to demonstrate that by saying that, for instance, the vote tallying created a lot of mismatch and inflation of votes in favor of President Uhuru Kenyatta, and that the electronic support did not really work as was expected. It was tampered with, and there was a constant figure being added, and that the provisional results that were being streamed by IBC showed a figure that was significantly higher or varied in a significant way from that which was announced ultimately, and that their agents were harassed and chased away in some of the polling stations. But I think if I look at the way in which IBC responded, because today it was NASA, maybe the petitioners presenting their case, and IBC having an opportunity to rebut that evidence, what they said is that, listen, election, as far as we are concerned, election was managed at the polling stations, and nobody has contested the polling station results. And if the polling station results remains largely untouched, then the will of the people was not vitiated as NASA, as the petitioners alleged. So it will be, there's a critical balance there for the court to determine whether, in totality, what the petitioners raised, whether they affected the core of the elections in terms of the electoral process, maintaining the purity of the electoral process and the integrity of the vote, whether that was largely preserved, as IBC claimed, or as NASA claims, that was really established that the electoral process was significantly tampered with. So that was their case.
Your thoughts on the impact of such a claim? And you'll remember they also cited Justice Lenola, one of Justice Lenola's judgments in a prior case, and concluded that if one cannot use statutory documents to verify results, then the results are inconsequential. And that started bringing in the question of this isn't about numbers, it's about the substance of the entire election process.
I think it's an interesting discourse, and I suppose it's going to be there between lawyers for a very long time. And the question is, on what basis do you impeach a presidential election? If you find that there has been substantial non-compliance with the law, and remember that the argument by the petitioners was that the non-compliance with the law, where there were either malpractices or where there were certain actions that were carried out by the IEBC, that those actions actually were transformed into constitutional breaches, to breaches of the Constitution, by saying that the principles that the Constitution sets are constitutions you do not violate, and that if you find that that has been violated, you don't even need to go the next step to ask, what impact did that have on the result? Now, if you look at the argument by the respondents, IBC in this case, they say, one, they say there were no breaches, and there were no willful breaches. Even where those occurred, were purely administrative. And in any event, those administrative mistakes did not in any case substantially affect the election. And the main principle, the main point that the respondents were making was that this is a constitutional principle, because it is about Article 1, which is about sovereignty of the people. So that the only question the court should be asking is, does this result reflect the sovereignty of the people? The question that the petitioner's team is asking is, does this result emanate from a violation, from a process that violates the Constitution? And what is the respective impact of those two areas, two issues?
Just another major one that they talked about was the abuse of power and the use of state resources. Tell us about that, Steve.
Well, I think it was the petitioner's case that, whereas the Constitution requires that state officers remain so and do not involve themselves in political activity that are partisan in nature, that was rebutted. And what sort of went unattended is that I looked for that and I didn't see it. Actually, on 23rd of May, just a few days, about 5 days before Parliament went on recess, they passed a law, one of the Election Laws Amendment Act of 2017, that allowed cabinet secretaries to mainstream government projects or successes during the election campaign period, and that went completely unattended. And I don't know, maybe perhaps what is going to be the reaction of that, but you know, overall, if NASA succeeded, or maybe the petition succeeded in demonstrating that yes, there was significant involvement of state officers in the campaign, and that affected the results, because you see what they had attempted to do in the beginning is that to set the guiding principle, sort of what shaped the legal philosophy of the court that would then be used to assess each and every other allegation that they may be trying to establish. That was the fact that if we are able to demonstrate that there was some non-compliance with the law, then the court should be quickly to accept that and not allow for excuse or explanation in terms of allowing IBC to explain why they didn't comply with the law. And IBC said, no. Look at the law in totality, but also look at our lived realities in terms of election management in this country. So the involvement of state officers will have to be looked at through those lenses.
Finally, Kambotho, because we are out of time, they also talked about not using 2013 as a yardstick. Could you explain that?
I think the principal issues in 2013 were one, the question, the important question about the responsibility that the court has if it finds that there have been violations in the law. I think it's a bit, and remember there was a lot of discussion about the effect of Section 83 of the Elections Act, which seems to indicate that you need to find first that there were violations in the electoral process, violations of law, and that those violations affected the result. That was number one. Number two, I think it was important for them to run away to the very strict, what they felt was a very strict interpretation of the responsibilities of the IEBC to a more value-driven propositions, where if you found that there were substantial breaches of law, then you needed to then find that the election was not carried out in compliance with the Constitution. Then there was that issue of that you raised about the involvement of state officers. There was a question even about the conflict, that apparent conflict in the Political Parties Act, which seems to stop all public officers from political engagement, to the Leadership and Integrity Act, which seems to allow the cabinet secretaries to be involved in partisan political activity. And the argument by the petitioners' lawyers was that that provision is unconstitutional, and in fact they sought the court to declare that section unconstitutional. So in a sense, we were trying to run away from the very strict and what they felt was, you know, very strict interpretation of the responsibilities of the commission and the other actors in the election process to a more open and more purposeful interpretation of the Constitution.
Right.
Yeah.
And we're going to wind it up there for this evening. Of course, we've not had all the responses to the issues that were raised. President Uhuru Kenyatta takes his turn tomorrow before the courts as he seeks to rebuff the arguments that were made this evening. Thank you so much for watching Monday Special, and of course, keep it Citizen TV. We will be live with that Supreme Court process throughout the day tomorrow, and of course in-depth coverage in our subsequent bulletins. Thanks for watching. I'm Anki Guta. Have a good night.